Hello and welcome to episode 9 of Business Litigation TV. This episode is all about helping owners and managers navigate the world of litigation and hopefully avoid it. So, to start off today, what I'd like to talk about is the NFL. I'm not going to get political about this, but yesterday the NFL came down with a rule that states that if a player kneels or protests or disrespects the flag in some way during the anthem, their team is going to be fined. And it allows teams to punish their own players in some way. So that made me think of contracts. In the world of business litigation, everything is governed by a contract. And you need, to avoid litigation, a good contract with clear rules. So in this case, using words that are ambiguous, like disrespecting the flag, opens up a lot of loopholes, as I'm talking about. For example, kneeling, probably going to be disrespecting the flag because that's where this whole rule came out of. So, what else would be considered disrespecting the flag? You put your fist in the air Black Panther style, is that disrespecting the flag? If you cross your fingers over your heart, like this, is that disrespecting the flag? There's going to be a lot of ambiguity, and I'm sure the NFL, players are going to find ways to get some kind of message across. So, what will they do? And what will the NFL do in response? Because they've left open a very ambiguous term. If they wanted to be direct, the rule should be you stand there, hands crossed or something, with your head down, head up, whatever they want, the exact way they want the players to behave should be delineated if they want to avoid people trying to find loopholes. Because good people, smart people, strategic people, like attorneys, are going to find a loophole. So, to bring this back to litigation, what you want to do when you're having a contract drafted, you want to have an attorney drafted. You want to make sure they're a good attorney who does not leave ambiguities and does not leave loopholes. A good contract avoids litigation. Now, it's never perfect, can't be perfect, but you don't want litigation over what a contract means. And a good attorney avoids that. That's the point of drafting a contract. You want everything spelled out airtight, with no ambiguities, so you are clear and understanding of what the terms of the deal are. The NFL has done this before, by the way. They recently but if you've watched the NFL, nobody understands what a catch is. They tried to rework the rule again. We'll see if it works. But because they leave it too open to interpretation. You have to catch the ball. You have to stay up for X amount of time. You have to make a football move. What the hell is a football move? Excuse my language and cursing here. But nobody really knows. So this is why they keep having to rework the rule, because they keep being ambiguous. I've had numerous discussions with people about this. What would be considered a catch? And I know I'm getting a little off topic here, but I love football. What would be considered a catch? As a smart, strategic guy, what I thought would be the best option, because there's kind of hard to avoid ambiguity. You can't just say it looks like a catch. What looks like a catch to one doesn't look like a catch to 5 others. You can't say you roll to the ground or you make a football move. It just doesn't work. What I think you have to do is you need multiple criterias, and you need to be able to do a certain amount of those criterias. For example, you make 5 criterias. You have to catch the ball physically. You have to hold it for 3 seconds or a second and a half, whatever. You have to move 2 steps with it. You have to be able to change direction. You have to hold the ball until your feet until your knees touch the ground. Something along those lines. Come up with 5 of them. Come up with 10 of them, and have 3 of them, 5 of them that you need to cross off. And if you cross off enough, it's a catch. So that was my thought. You know, you're never going to find a perfect system, especially in something as ambiguous as playing a game. You know, but if you come up with clear rules, you say, okay, look, he got 3 of the 5 criteria. We're calling it a catch. You can't argue with that. You know, so when you create rules, you create law, you create contracts, you want to make it clear. You want to be able to understand it. Excuse me. You want to be able to make sure both sides understand what they're getting into. Okay? Last example, I'll keep this one in law for you. I've seen contracts where it says someone has to do something in a reasonable amount of time. What's a reasonable amount of time? You're not going to put a number on it? 2 hours? 2 weeks? 6 months? Reasonable is way too open for interpretation. You know, I'd rather it be you've got 2 weeks to do something with, if necessary, a extra week built in, you know, a contingency week, something like that. Or 2 hours, whatever it is, but I want it spelled out. Okay? You know, and if you're so worried about, you know, not being able to get it done in time, you know, you say, let's say it's a week. You got 1 week to do this. However, if, you know, something outside your control by a governing agency prevents you from accomplishing something in a week, then you can extend it an additional week. But still you have criteria. You have things you have to hit. It's not just, you know, whatever I think's reasonable. No. Because 2 people will never agree on what's reasonable. Okay? You know, try having a fight with your spouse. You can't even find out what's reasonable between the 2 of you. All right? People are going to disagree. It's human nature. So try and avoid it. That's your job, my job. That's your job, actually, as the owner-manager. That's my job as the attorney. You want to avoid fights. You want to avoid litigation. You want to avoid disparity in thought. You know, you want things spelled out. You can go to the court and argue this wasn't a reasonable amount of time. You're never going to be able to go to the court and say, they had a week, they didn't do it. You know, and they're going to be like, well, we didn't think it was reasonable. No, you had a week. That's what the agreement said. All right? Your contract's going to control. Make sure whoever's drafting it is smart. I know it says 100 times already just in the last 7 minutes. Make sure whoever drafts is smart, strategic, and avoids litigation for you to the best of their ability. All right, that's it for me today. You've got any questions, concerns, tips, you want to just chat about, you know, about your situation, email me, jesse@jdelaw.nyc. All right. Until next time, take care.